I tried to make this video in complete detail, but it ended up being over 6 minutes long, so I completely scrapped it and I'm trying to start again. So I'm going to really try and oversimplify the fact that YNW Melly could be released on bond and what the fuck is an Arthur hearing. So YNW Melly's defense team have tried to get him out 3 times before. The first reason being that YNW Melly never fails to turn up for a court appearance, and not only that, but he's not a flight risk. But he was denied. The second time is when YNW Melly tested positive for COVID, would file a motion to try and be released on bond due to medical conditions. He was denied. This time they've implemented something called an Arthur hearing, and that's what makes it a little bit different. So an Arthur hearing in Florida is set to see if the defendant is eligible to be granted bond. The difference is that with an Arthur hearing, there won't be a jury. The only person that they have to convince is the judge. An Arthur hearing happens in 2 distinct parts, phase 1 and phase 2. During phase 1, there is a mini trial held. Instead of a full jury, there is only 1 judge present. During this phase, the judge has to listen to and consider the testimony of the defendant. The prosecution has the burden of proof, meaning that they have to show that there is no question of the defendant's guilt. The prosecutor has to prove the crime was committed by showing a great presumption and not just reasonable doubt, which is exactly what they've tried to go for in YNW Melly's case, and was one of the reasons why YNW Melly's case ended up in a mistrial, meaning that they might actually have a small chance with this. But we all knew that as soon as the mistrial came in, this was coming. During phase 2, it has to be decided where a discretionary bond is appropriate. Such things for the court to consider include the defendant's prior record, the seriousness of the crime, and whether or not the defendant poses as a flight risk or a danger to society. If the judge believes the defendant is deserving of release from custody, he or she will be set the bond amount. And it is entirely in their discretion how much the bond will cost. And with YNW Melly's case, that bond will be in the millions. As right underneath that it says, it's important to note that there is no restriction to the amount of bond when it comes to capital felonies, i.e. cha-ching, because it's going to be 7 figures. To help out with this process, what your attorney usually does is goes ahead and finds previous cases where someone has a crime similar to this and has been released on bond, which is exactly what his attorney did. They found a case from 1960, 1980 and 1998. Now they can only use cases from where this has been applied, but they've had to show that in certain cases the Arthur hearing was applied and certain people were given bond for a similar felony as to one like YNW Melly, because the prosecution only have reasonable doubt against him. As it states, the prosecutor has to prove the crime was committed by showing of a great presumption. They only had reasonable doubt, and that ended in a mistrial. YNW Melly's attorney also speaks about YNW Bortland and how he's on house arrest, because YNW Melly has been inside the entire time he's awaiting trial, whereas YNW Bortland hasn't, and he has 2 more additional charges on top of him as opposed to YNW Melly. But there's a huge difference there, because YNW Bortland is perverting the course of justice in their eyes. The prosecution actually stated that YNW Bortland would have to have arms like Inspector Gadget to make the shot. The difference being is that YNW Bortland is an acquaintance to the crime, whereas they're accusing YNW Melly of being behind the gun that took the lives of 2 individuals. Things that go in favour of YNW Melly is after they put out a warrant for his arrest, YNW Melly handed himself in. Now the public went ahead and immediately assumed that because he handed himself in, that meant that he was guilty. No, he just didn't want to be on the run. Imagine how that looks to a jury that you've got a warrant out for your arrest and the first thing that you do is run. You immediately look guilty. So he went ahead and handed himself in to prove his innocence. Unlike someone like, I don't know, Brian Kohberger, who waited 7 to 8 weeks before being arrested 2.5 thousand miles away before saying, I can't wait to get extradited back to Idaho to exonerate myself. Which seems to be working just great for you, mate. Brian Kohberger and his attorneys actually claimed that the grand jury's threshold was way too low and that none of the stuff that they said was eligible and that it should all be thrown out. Turned out that they hadn't even seen anything that had gone on within the grand jury yet. They were just making assumptions. So before Brian Kohberger had even seen what the grand jury had indicted him for, they were like, way too low. They've gone way under the bar here. They've done everything way out of code, when he hadn't even fucking seen it. Anyway, YNW Melly did actually hand himself in. He's never failed to appear for court. He is not a flight risk. And the case against him has just ended in a mistrial, presuming that the evidence against him just isn't enough to keep him in the position that he's in. But what's the percentage of this actually working out and YNW Melly getting out on bond? It's very low. It's about 5 to 15% that he's going to get out on bond, and 85 to 90% that he's going to stay exactly where he is. A lot of people talk about Idaho and all the mistakes that they believe have already been made in a trial that hasn't even begun yet. But you should pay some attention to the YNW Melly case. Evidentially, it would suggest that YNW Melly is the person behind the trigger that killed those 2 individuals that night. But the investigation was terrible in YNW Melly's case because they were looking for evidence of a drive-by shooting and not someone being inside of the car killing those 2 individuals. When YNW Bortland arrived at the hospital, he said that a drive-by shooting had occurred. So they immediately looked into the avenues of a drive-by shooting. ignoring the fact that that night 4 individuals had got into the car but only 3 arrived at the hospital. And when 3 arrived at the hospital, 2 of them are dead. And the only person missing was YNW Melly. And it just so happens that YNW Portland also forgot that YNW Melly was in the car that night, until evidence showed and suggested that YNW Melly was in fact in the car. Which is then when they remembered that, oh yeah, he kind of was in the car, but he got out earlier on in the night, where he'd gone over to his friend's house, Fredo Bang. Or where they suggested that he'd gone over to his house and let everyone in before going over to Fredo Bang's house and leaving everyone at his own home. Not only that, but the area in which YNW Portland said that this drive-by went down, they couldn't find any evidence of. In fact, cell phone locations pinged them in a completely different area, which is where they believed to have found shell casings from the night of the crime. As opposed to driving to an unknown location, YNW Melly pulling out a gun from his man bag, shooting his 2 best friends, getting out of the vehicle, shooting the outside of the vehicle to make it look like a drive-by, then messaging his now accomplice Fredo Bang to pick him up from the area in which the crime has just gone down so that he could get back as quickly as possible, change his clothing, and get rid of all evidence.